Hi, I'm Christian Wichard. I'm Deputy Director General at the Federal Ministry of Justice and Consumer Protection, and you're listening to IP Friday.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
I am Rolf Claessen, and my co-host Ken Suzan and I are welcoming you to episode 165 of our IP Fridays podcast. Today's interview guest is Christian Wichard, who is the Deputy Director General at the Federal Ministry of Justice and Consumer Protection in Germany, and he has been doing that for about 14 years with a short break from 2009 to 2014, where he has been Deputy Director General at the World Intellectual Property Office. He is overseeing all legislative efforts of the German government related to intellectual property, and we talk about many interesting topics. He had large contributions to the becoming of the Unified Patent Court. We talk about the role of AI in IP, about new reforms in the IP world. Stay tuned for this interesting interview. Before we jump into this interview, I have news for you. The USPTO has launched DesignVision, the first AI-powered image search tool available to design patent examiners through the patent end-to-end system. This tool uses artificial intelligence to support prior art searches in design patent examination and is part of the agency's broader efforts to modernize workflows and reduce pendency. In Europe, the EPO's Enlarged Board of Appeal issued a much-anticipated decision in G1/23 on July 2nd. The board clarified that a product already on the market before filing date of a European patent application cannot be excluded from the state-of-the-art under Article 54 2nd EPC merely because its internal structure or composition could not be analyzed or reproduced. Furthermore, any technical information about that product was publicly available before the filing date forms part of the state-of-the-art, regardless of whether the product itself could be reverse engineered. Just weeks earlier, on June 18th, the same board issued another important decision, G1/24, ruling that claims must always be interpreted in the context of the description and drawings, not only when ambiguities arise. This decision aligns EPO practice more closely with that of the Unified Patent Court and the US and is a major step toward harmonization. Speaking of the UPC, its case management system, CMS, has finally been fixed and transitioned to a new platform between July 3rd and July 8th. During the switchover, certain functionalities like opt-out requests and representative registrations were temporarily limited. Since July 8th, all filing capabilities have resumed, supported by updated FAQs and training materials. Finally, the EU IPO has expanded its mediation services to cover all inter-partes proceedings in the areas of trademarks and designs. As of June 2nd, 2025, parties in opposition or invalidity proceedings can now opt into mediation free of charge, fully online, and on a voluntary basis. So now let's jump into the interview with Christian Wichard. Today's interview guest is Christian Wichard. If you don't know Christian Wichard, he is the Deputy Director General at the Federal Ministry of Justice and Consumer Protection of the German government. And I'm very happy that you are taking your time to be on IP Fridays. Thank you very much for being here.
Thank you for having me. Thanks.
So just to clarify, and that's important, everything that you mentioned here is in this interview is your personal opinion, and you don't speak for the government of Germany. That is clear. Mm-hmm. And you have been Deputy Director General at the Federal Ministry of Justice and Consumer Protection for over 10 years now, and you are in charge of everything related to intellectual property in the government of Germany. So that's very interesting for our listeners of IP Fridays, of course. What have been the top 3 things you remember from this whole time that, in your personal opinion, have the biggest impact in the intellectual property world?
Well, first, let me start with a small clarification. I've been DDG in charge of IP matters twice, actually. First between 2006 and 2010. Then I moved to WIPO as DDG. Came back in 2015 to the ministry and back into IP in 2019. And yes, I mean, there are a number of IP issues that have been around during the last 10 years. And I think by far number one is the creation of the unitary patent and the unitary patent court, I think in my view, this is almost a once in a lifetime event, at least in the area of intellectual property. You have a patent that is valid currently in 18 countries and possibly in the future in the whole European Union. You have a specialized patent jurisdiction with judgments that are enforceable in all 18 participating countries. I think that in itself is already a huge achievement that makes patent litigation much easier in Europe. It lowers the threshold for SMEs into the patent system. It also contributes to Europe's competitiveness. And I think it's also a unifying force beyond the patent family. So it's the first civil or private law European litigation system we have. Number 2 was already a bit more difficult. So here I'm hesitating a little. But probably it's the EU Directive on Copyright and Related Rights in the Digital Single Market that was passed in 2019. And our implementation in the Urheberrechtsdiensteanbietergesetz, so in translation that would mean law on the responsibility of service providers under copyright for the sharing of content. Already the directive was hotly disputed and quite heavily criticized. But in the end, I think it did its job. It aims at extending copyright and related rights into the digital environment, including all limitations and exceptions. And this is a very complex process. And hotly debated in particular was Article 17 of the directive, which clarifies the responsibilities of content sharing platforms. And here, just to explain a little. So these platforms make a business out of making content available online, but traditionally, they haven't really borne any responsibility for copyright infringements that happen on these platforms. So new is now that they can be held accountable for material that is posted by users on their platform. So the directive considers this posting by third parties, by users, as an act of communication to the public by the platform itself, which might trigger liability. So that means that they must themselves either try to get a license for the copyright protective works that are posted there, or must prevent it from being made available, even if they haven't received a warning. So this goes beyond the notice and takedown system that was established by the e-commerce directive. And this also provoked this discussion on upload filters. We had demonstrations in the streets and everything. But at the same time, the DSM directive also stipulates the principle of proportionality. It explicitly states also that there should be no general obligation for providers to monitor everything at all times. And it also safeguards exceptions and limitations. So in a way, you're looking at a quagmire. It's difficult to implement that into a national law, given also the different legal traditions that we have. So that was the challenge we were facing, trying to implement that, doing justice both to copyright protection as well as to exceptions and limitations, the countervailing freedoms and rights that have to be guaranteed, and to make that implementable in a way that's also possible in a technical environment. So I think, I'm not going into any further detail. I think in the end, in our implementation, we've done a reasonably good job. It was indirectly confirmed by the guidelines that were later passed by the EU Commission, so after we had already passed our law, and also by the ECJ judgment that came out a bit later. So I think that was number 2. And perhaps number 3, the second Patent Law Modernization Act which we passed in 2021, not so much for all the rules that are new or that have been reformed there, but more because it touches on some key features of the German patent litigation system. And in its key part, this Modernization Act seeks to address certain consequences of the bifurcation we have in Germany. The bifurcation between, on the one hand, invalidity actions that are handled by the Federal Patent Court, and which include technical judges, on the one hand, on the other hand, infringement actions that go to the general civil courts, some of which are rather specialized. And this bifurcation is a very German tradition. And the reason why we have it is patents are granted only after extensive examination by technical experts at the patent office. And they should not be declared invalid quickly by lawyers, by legal judges. So that's why the infringement court should normally treat a patent as valid unless there are very clear indications that it might not be valid. And then they can hold the procedure. But typically they would have to treat a patent as valid because it has been examined. But that also means that infringement actions can proceed really quickly. So in under a year, you can have a judgment that is enforceable in Germany, and you can have a really strong injunction against an infringer. And that, in a way, is the strength of the German system, the speed with which you can have an infringement judgment. But the declaration of invalidity then only takes place before, as I said, before the Federal Patent Court in a separate procedure involving technical experts as judges. And I think that in itself, those principles are still valid, and I think Germany is well in keeping them. Problems sometimes arise because there may be a time gap, or there often is a time gap between the invalidity action, Federal Patent Court on the one hand, and the infringement action. So the invalidity action often starts later and takes longer than the infringement proceedings. And that means that in extreme cases, it might happen that you get an injunction issued on the basis of the patent that is later declared invalid by the Federal Patent Court. In extreme cases only, but still, it might happen. And then there is a question of patent quality. Is the assumption still correct that patents are granted on the basis of a thorough technical examination? So some are questioning that, less so perhaps with regard to the German office, but more so with regard to the European office. Not I'm saying that EPO patents are bad, but there has been a patent quality debate relating to the EPO. So the second Patent Modernization Act has made efforts to address the negative consequences and to address them within the system without changing bifurcation, but to make it a bit more viable, so to say. So is a shorter deadline for in a way, it is meant to speed up invalidity proceedings. There are shorter deadlines for filing a response in invalidity actions before the Federal Patent Court. And then the Federal Patent Court also should issue a first early substantive assessment as to the patent validity within 6 months. So parties should get an indication of whether the court thinks that a patent is valid or not reasonably early in the procedure. And that can then also be included in the invalidity procedure. And the invalidity court can decide whether on the basis of this early opinion, it might have to hold the proceeding, the infringement proceeding, until the invalidity action is over, because there may be indications that the patent is invalid. So that is meant to, in a way, bring both procedures closer together. And another aspect of the act was that we also expressly included a provision into the act now that allows a court in exceptional cases to grant damages rather than an injunction. In those cases where granting an injunction would be disproportionate in such exceptional cases. So that is meant to serve as a safety valve and not meant to undercut the strong and enforceable patent rights, which are a stronghold in a way of a key feature of the German patent system. Sorry, it was a bit long, but I think those are still three key things that happened over the last 10 years. But again, I mean, I think number one definitely is the unified patent court.
Yeah, we will talk about the unified patent court, but first maybe my feeling is that the German patent system, one of the major differences to a lot of different other legislations is the injunction, that you can get an injunction, compared, for example, to other important countries like the US, where it is very difficult to get an injunction. And my understanding and feeling is that since the reform, there has not been really a lot case law denying the injunction and just rewarding damages. So I think the big fears of the patentees have not become true so far. Let's see how this develops. So
it's just meant as a safety valve. So it's not meant to be like the regular feature of patent litigation.
Right. Yeah, you already mentioned the Unified Patent Court. You have watched very closely how the Unified Patent Court was established. And in fact, you have played an important role in the formation of the Unified Patent Court. Can you briefly describe your role in this process where this became a reality, the UPC?
Yes, I participated in two phases. In a way, first in the early and the formative phase between 2006 and 2009. So in the early phase, first between 2006 and 2009, early phase, and then between 2019 and 2023, again as a DDG here in the ministry. In the early phase, I mean, our job was to voice the key concerns of the German government, and those concerns were with regard to the community patent system, as it was called at the time, which then became the uniform patent, an efficient system, efficient patent granting system with a limited language regime, which would then reduce the cost of the translation cost, but also reduce legal uncertainty arising from the translation requirement, because you never really know what are the whether there may be any differences in between the different language versions as far as the claims are concerned. And also the cost benefit for the price, that the price should not exceed that of a European patent valid in 4 countries. Cost benefit. But also the second major concern was that there should be a high quality and efficient court system. High quality means also a specialized patent court, a specific patent court, not a general court, but a patent court with expert judges, including technical judges. So that was, in a way, the German position from the outset. Efficient procedure that should run quickly, and also a cost-effective procedure. And the key decisions in this regard were already taken in 2009, 2010, when the EU Council adopted the first common position. So that was, in a way, when most of the content had already been developed. And then in 2019, when I was back, we had to address a lot of difficulties resulting both from constitutional legal challenges here in Germany, difficulties resulting from the Brexit, and trying to sort all that out was quite a handful. So passing the ratification, then the law ratifying the procedure. Also overseeing the development of secondary law, the rules of procedure, like the first European set of rules of procedure for a private court system, schedule of fees and so on. And then in the end, supporting the establishment of the court in 2023. In a way, in administrative terms, it still is a startup with a very small secretariat, very small administrative unit. So they still need a lot of help from member states.
Right. It took a couple of decades, actually, as you mentioned already, for the UPC to finally open its doors. The idea is really old, and the process has been quite long and tedious in some phases. Why, in your personal opinion, did it take so long to establish the Unified Patent Court?
Well, I'm not going to talk about the period before 2009 and so, because I think there was quite a mix of things. One was also linguistic differences. On the one hand, efficiency, on the other hand, like multi-linguistic approach. But I think after 2010, or I think after the key features were established in 2010, the difficulties arose not so much from the content of the system, to a certain extent, yes, but from external factors. So first we had an opinion of the ECJ that was necessary. We were asking, member states asked basically for an opinion from the ECJ that was delivered in 2011. Everything was fine. We just needed to do some adjustments. Then Spain and Italy didn't want to participate for linguistic reasons again. So 2012, for the first time in the EU, reinforced cooperation was used. So the Council adopted the European patent package without Spain and Italy. And that was in a way the unified patent. And then 2013, there was an agreement on the establishment of a European Patent Court that was signed by all member states except at the time by Spain and Italy. So those were the key elements, the European Patent Package, EU, and the ECJ agreement. And then Spain started challenging the council decision before the ECJ. It took some time for the ECJ to come up with the decision. That came in 2015. Everything was fine, one thought. Then next, in a way, we moved to Germany, and then unfortunately the problems were created in Germany. There were a number of challenges before, no, really only one challenge before the National Constitutional Court here in Germany. It was filed in 2017, and that meant that we had to withhold ratification. We wanted to be one of the first to ratify. We couldn't because we were asked not to, as long as the court procedure was going on. It took the court a while in 2020, unfortunately, with a negative decision. A decision that basically declared the act that was meant to support the ratification by Germany of the UPC agreement invalid, but only for purely procedural reasons in the lawmaking process. So we had to pass a new law. That was in 2020, in the same year. So that was really a speedy process. We passed another law with the same content, more or less, but now in the right procedure. And then 2020, we passed a law, but before it could be signed into action, another challenge would have been filed. So we had to hold ratification again, but this time the Constitutional Court was faster. In 2021, it basically confirmed everything is fine. And we were then in a position to ratify. The other difficulty was the Brexit that came in between. So the UK was a key element in the whole system, and it was one of the three countries that had to participate, that had to ratify in order for the whole system to enter into effect. The three countries with the most patent activity: Germany, France, and the UK. Then, since the UK couldn't participate anymore, that had to be adapted as well. And then Italy was construed to be the country with the third most intense patent activity in Europe, and was construed to be the UK in a way, in the sense of the treaty. So with all these complications, once all these complications had been cleared, final preparations were made, and then we, as Germany, formally ratified in February 2023, and that allowed then the court system to enter into effect in June 2023. So that's a bit like the long and winded road to the UPC, but I think we can be quite happy that in the end we are there.
Right. It was a long journey, but worth it. I think it's a very good instrument. But I wanted to ask you what you think, what the most important advantages of the UPC are. Why did we fight so long for this system? And is Europe now in a position to compete with patent litigation venues like in the US or China or other very big jurisdictions?
Well, of course, in a way, you always have a captive audience. If you want to enforce a patent in Europe, you have to go to Europe. And for example, looking at how many US companies use the unitary patent, as well as Chinese, I think it can't be that bad. But I'm not a specialist either in China or US patent litigation. I think the key advantages of the UPC system are first, the territorial scope. I think that's a big achievement. You have only one procedure for handling a patent dispute, and that you get a judgment that is valid and enforceable in all 18 participating member states. And also you have a procedure that will contribute to the development of a unified European patent case law, which then also will lead to more legal certainty throughout this single European patent litigation space, to say. So first, territorial scope. Second, I think efficient and cost-effective procedures. A single action in the UPC, in most cases, will be more cost-effective than multiple national jurisdictions. But even if you look at the current fees, very often a UPC procedure can be even cheaper than a German court procedure if you consider that you have to go through infringement as well as a validity procedure plus several instances possibly. Then also the UPC's rule of procedure are designed to expedite proceedings. So typically the first instance decision you will have within 12 months after commencing proceedings, and that still holds. So they still manage to get the first instance cases through within 12 months. And then also you have a limited language regime. So typically it's the language of the patent, but also before all local divisions, before all local chambers, you can use English. So that's been authorized. And the third advantage, I think, is expertise. In the court, you have the most experienced patent judges from the participating member states. And they were selected not by member states, but by an independent expert body that is not liable to political pressure. And I think that's also a big advantage. And again, this also contributes to the fact that the UPC is really recognized as a good patent court, as at least equivalent to the German patent litigation system we had. And the other key advantage is that you can also have technical legal judges as part of sitting there as part of the chamber, and they're involved at the same level in order to address technical questions. So territorial scope, efficient procedures, and expertise, I think, are the key advantages.
Yeah, and more countries are joining, so it's really a growing system. I think Ireland might be joining sometime, and also other countries thought about joining. So yeah, it's growing, and the usage is increasing a lot. I mean, we see the figures that are published monthly by the UPC, they are all going up. So
yes,
the acceptance is rising.
Mm-hmm.
But now let's switch topics a little bit and move to the EU IP harmonization package. The EU wants to reform the IP in Europe and harmonize it. What is the goal of this package, and what are the most important components in your view?
So what we currently have is the patent package, and that includes 3 dossiers, which are each by itself rather heavy. So first we have a regulation aiming at establishing an EU-wide compulsory licensing system, a hot political issue. Secondly, we have the dossier relating to supplementary protection certificates. And that is a set of regulations harmonizing the granting of national SPCs in a single European procedure. So that's two regulations. And another set of regulations establishing a unitary SPC as the long-awaited complement to the unitary patent. So that's the second element. And the third element is a regulation on SEPs aiming at enhancing transparency and facilitating the licensing process. So that, again, also is really difficult, rather complex, and quite hotly debated.
Yes, opinions go in all directions at the moment.
Yes.
Right. So the EU Commission has withdrawn the SEP component of this package. What is the current status and with regard to SPCs and compulsory licenses in your opinion?
But a small correction, the SEP dossier has not yet been officially withdrawn, but the Commission has announced its intention to withdraw, but has given the Council and the European Parliament an opportunity to comment. And the EP, the European Parliament, has been very clear. They are very clearly against the withdrawal. They're very clearly against the withdrawal and have made that very clear to the Commission. The Council is split, unfortunately. We didn't really have a possibility to discuss the substance of the proposal because we were so busy with compulsory licensing, SPCs, that no presidency so far had really scheduled in-depth discussions of the SEP dossier. But in the end, 10 countries, including Germany, France, and Italy, were opposing the withdrawal, again, very clearly, whereas about as many were for a withdrawal. That include in particular Sweden, Finland, the Netherlands. So in a way, Council was split. And the withdrawal would be unfortunate from the position of the German government, because while we were not happy with each and every element in the SEP proposal, we still think that it is better than nothing, and that it serves as a good basis for a substantive discussion in the Council with a view to reaching at least a qualified majority that is necessary to pass it. The alternative is nothing. And I think that would not be good, because we feel, at least in the German government, there is a need to enhance transparency and also to provide some guidance as to licensing negotiations. And that is obviously quite difficult at the time, as we see from the different various court decisions that are rendered in the EU. So quickly on the compulsory licensing proposal, since you asked for the status, the agreement has been reached between Commission, Council, and the EP in the so-called trilateral negotiations in May 2025. So currently, there is legal scrubbing, so meaning that the legal services are looking at the language, making sure that everything is correct. So the formal adoption will take place at one of the next Council sessions. We don't know exactly when, but that will happen. So the proposal which we care the least for is the first to be ready on compulsory licensing. Second, SPCs, standard supplementary protection certificates. And there the discussions in the Council are really complicated. Complicated for at least 3 reasons. So one is that the Council Legal Service, unasked for, has questioned the legal basis has used for its proposal. And the legal basis, Article 118 of the Treaty on the Function of the EU. And the argument is that such unitary SPCs would be valid de facto only in 18 member states that are currently participating in the unitary patent system. And that, they say, does not qualify for a title that is valid throughout the EU. And this is the formulation that is used in Article 118. We feel it doesn't hold. That argument is not valid. The Commission Legal Service feels the same, but still, it's a stumbling block currently there. Second problem is that most member states, if not all member states, want to safeguard the involvement of the Unitary Patent Court. And they want to make sure that the UPC will be responsible for direct as well as indirect invalidity actions. And we have a problem if the EU IPO grants the title, since then a direct invalidity action would probably have to be heard by the ECJ. That at least was the opinion of the Commission Legal Service. And that was in a way, that's why we felt that it cannot be the EU IPO as the direct granting authority. Then a number of member states said, okay, let's involve the EPO. But here again, we are facing problems, because if you want to involve a non-EU agency as the direct granting authority, you have to stretch EU law quite a bit. And it's probably not possible to have the EPO as a direct granting authority. So here we are currently. So we're looking at a mix of legal as well as political issues that relate both to the legal basis, to the involvement of the UPC and the rendering institution. But Fortunately, we have a very ambitious Danish presidency, and they've declared that they want to conclude the discussions by the end of the presidency with at least a qualified majority.
Yes. Okay, so interesting to hear the status from you, because you are insider, basically. You are in discussion with your colleagues from the other countries, trying to achieve an agreement and trying to achieve the best for the users of the system. So I'm very grateful that you are participating there. Since you are here in the podcast, I also wanted to ask you something else that has been in the news also, but also a hot topic among IP professionals. What are the current discussions about copyright versus artificial intelligence on a government level? Can artificial intelligence be a creator in the sense of copyright? Can copyrighted material be used for training artificial intelligence? I mean, there's the first decisions coming out now in the different countries now, but maybe your opinion, without the consent of the creator, can this happen or not? And what is the current status in this field, in your opinion?
Well, I mean, this definitely is an extremely hot topic, and a topic that really is of big concern to stakeholders in the creative industries. And they're very concerned with the fundamental impact that generative AI may have. Okay, on the one hand, it's good because they can use it for their creative activity to make it can help to make their creative activity more efficient. But they're also concerned that AI-produced content might replace content that is generated by humans, and we see that already. We see that translations can be done by machines, automatically. That music, at least background music, can be done by AI. Press articles, news items can be produced by AI, and all that. So how can we then make sure that copyright can still help creators to make a living from their creative activity? So that's in a way the fundamental question, and that's why the whole topic is so both difficult as well as politically charged. And that's why the ministry, we are in charge also of copyright, is very active. So we've not so much in the press, but more in the background. We've organized a conference, rather an international conference early last year. We're one of the first in a long row then of conferences on that topic. And we also contributed rather actively to the discussion in the council. But perhaps also quite importantly, we are in touch with the Commission in order to prepare a debate at the EU level. And we feel that any such debate should not be limited to the text and data mining exception that we already have in the Digital Single Market Directive. And here we need to have an evaluation next year. But we feel that we should not wait. And we shouldn't just be limited to TDM, because the discussion is much broader, and it should start now already with a view to finding solutions. And a number of the questions you already listed. You asked, can copyrighted material be used for training artificial intelligence without consent of the creator? To a certain extent, the answer is yes, but it depends. It depends on whether it relates to commercial text and data mining, because if it is commercial text and data mining, then the copyright owner can opt out of the exception. So they can simply say no. And then their works must not be used for text and data mining. And that was in a way meant to foster the establishment of a licensing market, because if you can say no, you can also ask for a price in return for saying yes, so for a license. The problem, however, is transparency. You never really know whether your work has been used or not, because it just happens, and there is no trace in your work whether a machine went over it and used it for text and data mining. The AI Act, the EU AI Act, has imposed certain transparency obligations on AI providers. For example, a summary of works used for AI training, and it also states that it must be meaningful, so it should be sufficient to establish a prima facie case in court. So yes, my works have been used, And how to apply that is currently being discussed. And I'm not going to any much detail, but in several working groups and working processes which are managed by the Commission. So they are aimed at establishing code of practice and a template for such a summary. So that currently takes place. So that's one of the big questions, text and data mining. Next question, can AI be a creator? Well, the answer, in my view, is not as such. But the work created with the help of an AI may qualify, depending on the amount of human input that was used to generate the work. So if basically it still is a human work, a work generated by human creativity, using AI as a tool, I think that still is a work that qualifies for copyright protection, but not if it is merely produced by AI. Can AI produced output infringe copyright? Another question you asked. Probably, but only then if the output is more or less the same as the work that might be infringed. So even though you could also ask, well, it all went through like a probability through this algorithm, and the outcome is just a coincidence. No, but I think if the output is basically a copy of the original, I think that would probably be an infringement. The question is also whether AI-generated output should be protectable by copyright or related rights. Here, our position is probably rather not. Currently, at least, there is no need to stimulate investment in AI-generated content. But again, the overarching big issue is underlying the current remuneration system for creative professionals.
And that's what I wanted to ask. I think there has been an official opinion by the government regarding the remuneration of creators for streaming or private copies. Can you summarize the main findings and suggestions by this official opinion?
Well, since it's not out yet, but will be published in the next weeks, we've received it recently. But we're currently preparing it for publication. And this expert opinion, which we asked for, really is devoted to two questions. One relating to the remuneration of creators in the platform economy, in particular with regard to streaming. And that should cover all areas except music, because there was already another study commissioned by the Federal Commissioner for Culture. So there we already have another study. So there was one part, remuneration of copyright in streaming, of copyright owners in streaming. And the other part was remuneration, checking the remuneration system for private copying, which is authorized under German law. We have a rather elaborate system there, which has been around since the late 60s, early 70s. Has been reformed a couple of times. Now the question is, does it still hold? So as I said, I won't go into details of the result, just to say the good news is we do not need to, there's no need for a fundamental overhaul of the system.
That's good to know.
Yes,
good to know.
We can keep the basic elements of the system, but there are still some suggestions aiming at enhancing, in particular, transparency. Who gets how much, and how do we develop like the value, and what is the adequate level of remuneration, and also aiming at enhancing efficiency within the system.
Do you have an opinion or an idea when this official opinion will be published for everyone to read?
Well, we just asked for authorization to have it published, so it should happen. Normally, our political leadership is rather quickly in granting authorization, so it could happen next week or in 2 weeks, just in time for the summertime for you to take a long and read on the pool.
Yes, and maybe we are recording this mid-July, so maybe by the time this podcast is published, it's already available. Let's see. Mm-hmm. Maybe if it's already available, I will include a link in the description below this podcast.
I'll send you a note, yes.
Yes. So it has been really great to have you as a guest in this interview, and I'm very grateful that you took your time. It's not often that I can have the chance to meet people who really drafted and sculpted the landscape, the IP landscape in Germany as much as you did. So I'm very grateful. Thank you very much.
But just to say, I'm not doing that alone. Of course, we have very qualified colleagues here in the ministry who are in charge of copyright, patent law, also trademark law and fair competition. And of course, I'm not the only one working on those matters.
Right. But you oversee the efforts, and yes, thank you so much. Thank you very much.
Okay, thanks for having me. It was a pleasure.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.